Looks like everybody's ready. We're now here ready for the oral arguments in State versus Allen. Mr. Mullins, you may go first.
Good afternoon. May it please the court. After all this time, I feel I need to introduce myself. I'm Darrel Mullins, and I work in the Criminal Appeals Division at the Attorney General's office. We're here today because the Court of Appeals held that assault while displaying a dangerous weapon was a, quote, wholly new and different offense from assault causing bodily injury and therefore violated State versus Sharp. We believe that's incorrect, and we ask this court to conclude that so that we may know when it's appropriate to seek to amend a trial information or it's appropriate to dismiss that trial information and file something new. Now, Rule 2.48, as you know, permits an amendment, or at least permits the seeking of an amendment if two things occur. One, there's no proof or there's no prejudice to the substantial rights of the defendant, and it doesn't allege a wholly new and different offense. So in cases from Sharp, or actually from before that, Furman, all the way on through Abrahamson, we know that if you are alleging an alternative of a base prohibition, the discussion about whether you have the two offenses are wholly new and different is largely over. You then go on to determine whether the amendment would prejudice the substantial rights of the defendant. However, if you can't conclude that the two items are alternatives of a base prohibition, then you need, like as in Abrahamson, you need to consider a broader array of factors. I hesitate to use the expression of totality of circumstances, but it'll suffice for now. So you'll consider the placement of these issues or these alternatives within different parts of the code. Are they in different chapters? Are they in different sections of the same chapter? Then you can compare the elements, and you can consider what punishment there is for at least what guidance it might offer for purposes of how the legislature views these two particular issues.
Counsel, so what is the base offense in your view?
Assault.
So any assault under Chapter 708?
I hesitate to say yes, because I'm somewhat less familiar, though I understand we have Vandermark as well, which talks about willful injury and assault with intent to commit serious injury. And I can mention that briefly, though I'm less familiar with it. But I am confident that for purposes of 708.1 and 708.2, the alternatives within 708.1 subsection 2, A through D, are clearly alternatives of the base prohibition of assault. And if you read 708.2 out loud to yourself often enough, you hear yourself saying assault, 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 assault under 708.1.
So how far does that go? Meaning, much of the criminal code is structured with a definition of a base offense and then has subsequent statutory provisions delineating degrees. So just quickly, if you look through our code, theft, burglary, arson, robbery, kidnapping, sex abuse, assault, and murder have the same structure in that they define base offenses and then degrees with proof of predicate facts. So unless the state's position is it can always upcharge at the amendment, meaning you can move upward among these different degrees of offenses, how do we distinguish, for example, Sharp or other cases? I just don't see an end to it, basically. You can move from Berg first to Berg third, or Berg third to Berg first, and it's no problem because it's the same base prohibition. Is that right?
Not exactly.
Why?
The base prohibition for first-degree murder is first-degree murder.
Let's use the burglary example.
Okay. So with burglary, I would say that so long as we are talking about the base prohibition of that burglary, and then we're looking at the general provisions within, if they're following within that section, okay, then yes, the answer probably is it's not wholly new and different. However, that doesn't necessarily mean an amendment is proper, because the further away you get between the two offenses, the less likely it's going to be that the defendant will either be able to meet it. Now, by the way, this is analogous to the argument that I dealt with in State versus Abrahamson, where I presented largely the same argument that the Court of Appeals embraced, and that, as I understand it, the defense proposes now. And that is that these are all separate and distinct offenses. If you think about the elements, they're separate and distinct. And particularly if you apply the thinking from the federal courts, you would then need to re-examine Abrahamson, because as you get into that provision, you can see, well, possession of marijuana is an entirely different kind of crime than conspiracy to manufacture methamphetamine. And so in that circumstance, while Abrahamson was quite clear that all of the prohibitions within 124.401, those are all alternatives. And so while you might say that they are the same for purposes of an amendment, it might be less clear that it would be appropriate to amend in any given case.
It seems like if you, at least as I read the cases, outside the context of drug trafficking, that if there's a different element and increased punishment, then that is a prohibited amendment. That is a wholly new and different amendment. If it's alternative means of committing an offense with the same punishment, then that's permissible. Can you think, is that a fair kind of reconciliation of the case law?
I think it's fair enough. I'm less familiar with instances. However, I would say that on the one hand, assault is its own creature. It's different than 124.401. It's different than 707. It's unusual in the sense that it fairly closely ties the two 708.1 and 708.2 together. And so because of that integration, I still think that the state could have prevailed here in a successfully amending, notwithstanding the fact that it changed the crime from a serious misdemeanor to an aggravated misdemeanor. I would have to think more carefully about, say, for example, in the sex abuse context, changes from one alternative to another and whether it elevates based on the nature of the conduct. But sure enough, but then we kind of run into the problem if, well, unless you're willing to make a conclusion that drug offenses are just different, then drawing the conclusion that you offer will require a considerable amount of work to continue to follow the law in 124.401. And by the way, this is an approach that has existed now for something on the order of 45 years, and Abrahamson is 17 or so years old, or might not be that old. So I think what we ought to at least bear in mind is the notion that over the course of time, the legislature has shown a considerable amount of deference to this court's interpretation of Rule 2.4.
And what was the offense in Abrahamson again?
It was, I think they tried to dismiss one of the, maybe it was a possession of a controlled substance, and they wanted to refile for a conspiracy to deliver.
Maybe that is the answer, right? Maybe drugs are different because it's a very convoluted statute that has, I think one case said 36 alternatives of committing the same base prohibition. And maybe we just leave drugs alone and treat other offenses differently.
Well, of course, you have the ability, of course, to do that. I suggest that what it will end up leaving us with is something of the, mess is too strong of a word to express it, but we are beginning to see a fracturing of decisions from in the Court of Appeals, and we're certainly fielding calls from prosecutors trying to determine, is this a circumstance where I need to seek to amend this trial information, or do I file a new one? And the problem that we would seriously want to avoid is a situation where you can neither amend and you can neither file anew, because to file a new one, this is the same offense, and to file for an amendment, you're saying, well, you can't because they are different offenses.
Yeah, I mean, here, you've given a thoughtful way of looking at it. Let me throw out another way of looking at it. You have two cases from 1981 that are 4 weeks apart, right? Sharp and Williams. And Sharp has a pretty restrictive view, and I would argue helpful to the defendant here. It says, if you have a different element and more severe punishment, then you can't amend. Williams says if you have a different means of committing the same basic crime, that's okay. I mean, can we say that maybe, Williams amended Sharp? Is that possible?
Well, it's possible, but maybe I can fill in the blanks. Remember, of course, this is 1981, and the court is still trying to determine, is it going to apply the strict elements test for purposes of lesser included offense analysis? Is it going to apply facts? And so it wasn't until Jeffries that the court really landed on the elements analysis, okay? So at the time Sharp and Williams were in the works, I think the court hadn't entirely settled on its method of analysis. And so for my money, the reason that the court first talks about this broader discussion of code sections and punishments and that sort of thing, and then says, but we still need to adhere to Furman because alternatives are different. Those are not wholly new and different offenses. And so I think the court in Sharp might have been better served to start off with where it had ended, but it hadn't yet sorted through Jeffries. So I think we might be able to explain it that way.
Was there prejudice in this case by the late amendment?
No.
And why not?
So if you're with me that this doesn't allege a wholly new and different offense, it's not prejudicial because, well, for one thing, if you look at the structure of the statute, you'll know that even if we had prosecuted this on the assault causing bodily injury, it requires proof of an assault, and one of those alternatives is the use of the vehicle. So we were going to have to prove the use of the vehicle anyway. Furthermore, the minutes were replete with evidence of a bodily injury. So it isn't necessarily the case that any of her defenses would have been impacted by the amendment at that point, because if she wished to dispute the sufficiency of evidence related to the bodily injury, she was going to have to testify. And there's evidence in the minutes, and there was evidence at trial, that she was one of the people, or at least she was aiding and abetting others who were driving vehicles and drove this man down. So one way or another, the case wasn't going to be any different. And furthermore, when we're talking about prejudice, it's somewhat helpful as you examine these cases to consider the time at which the issue arises. So if you're moving to amend to conform the proof at the end of trial, I suggest that the chances are better that the amendment could have prejudiced the defendant's substantial rights. But on the other hand, if this is coming up before trial, then there's an opportunity for a continuance, which is what the court has said is the appropriate antidote for the potential for a surprise. And let me, if for no other reason than to defend the good name of a prosecutor who said, I filed this early. It's true enough that that EDMS doesn't show the proposed order, but we do have his statement on the record, and defense counsel indicated in her motion for new trial that the state had attempted to amend something like a week earlier. It's just that the judge hadn't gotten to it or signed it or dealt with it until the morning of trial. It's for these reasons that we believe the Court of Appeals erred. And we think that the better approach, perhaps, is to clarify Sharp, make clear the nature of the rule, and then, for the benefit of the bench and trial prosecutors, they'll have a better sense of when it's appropriate to file a motion to amend and when they need to file an additional trial information or seek to dismiss the first one. Thank you.
Thank you. Mr. Dickey.
Madam Chief Justice, and may it please the court, I'm Gary Dickey, appearing on behalf of Jamisha Allen, who asked the court to reverse her conviction. As I understand the state's argument, they seek further review to try to provide a uniform standard under Rule 2.33 as well as 2.4 subsection 8. And while that may provide them with ease of guidance, it's not necessary because those two rules are really designed to attack two different issues. Under 2.33, it's the circumstance under which we make sure that the process of a criminal prosecution speeds along. So there's a speedy trial, speedy indictment component to it. And then there's also when can it be refiled, which raises double jeopardy concerns. That's not the purpose of Rule 2.48. And just compare them textually. Under the text of Rule 2.48, which has been lost in the state's analysis, the opening sentence says that the purpose of the rule in the text is to correct errors and omissions. So it's not designed to allow a prosecutor to wait even 6 days before trial and use an amendment to an upcharge as the way of trying to coerce somebody into a guilty plea, which is what this record shows. So this wasn't a situation where the prosecutor came in the day of trial and said, all along I've had an error or omission from day one of the trial information, and therefore I need to amend to correct it. Additionally, what the state's argument overlooks, what the Court of
So,
Appeals...
as I understand that, you're saying the purpose of the rule is really non-material Scrivener's type errors, wrong code sections in the trial information, wrong names, things like that.
Or to conform to the evidence. Clearly, those types of errors are contemplated within the text. I do recognize there may be a situation where it may be appropriate to amend for some other reason based on an error or omission. And so I don't trust my imagination to rule out that possibility, but textually, that's the purpose. And that would be consistent with the way that this court had interpreted the rule in the 60s and 70s, recognized in Sharp, I think correctly recognized by the Court of Appeals, that it's supposed to be, amendments are supposed to be relatively narrowly construed or narrowly allowed. Certainly not contemplated for the purpose of waiting to the day of trial to coerce a guilty plea, which is the stated reason here.
Does the record show that your client, that Ms. Allen, would have pled guilty to the original charge if she had known the upcharge would be allowed?
I don't think the record shows that, so I'll concede that.
Does that then, how do you show prejudice?
We show prejudice because defense counsel went to trial on a strategy that the state couldn't meet its standard of proof. Admittedly, they couldn't meet their standard of proof because they had an uncooperative witness who couldn't testify as to the extent of a bodily injury. So their strategy was, we're going to show up on the day of trial. His statements will not be admissible under the Sixth Amendment or under hearsay. They've got nobody that can testify to the bodily injury. They're not going to be able to make their case. Had the amendment not been allowed, I think it's fair to surmise the charge would have been dismissed for lack of evidence. So that's the trial strategy, not necessarily to wait and see if they can get a better deal. That's where the prejudice to the substantial rights comes in part. The other part would be we went from serious misdemeanor to an aggravated misdemeanor, which carries all kinds of collateral consequences that are different, which is important, and we pointed this out in our reply brief. The standard is prejudice to substantial rights. It's not substantial prejudice to the rights of the defendant. So those are significant differences. So going from a serious misdemeanor to an aggravated misdemeanor, that's a serious right. I mean, that affects the potential for prison, the requirement for DNA. So that's a prejudice to substantial rights in and of itself, the upcharge. So for that reason, we would submit that even if we're wrong on the wholly new offense, which we don't believe we are, but if we are, it's still prejudice her substantial rights.
So how do you reconcile your position with McGee that allows an upcharge from the C to the B on a drug trafficking offense, which does seem to, again, prejudice substantial rights? You've got a pretty severe increase in the penalty. doesn't that seem to indicate that the state is right, that the state is allowed to amend the trial information to upcharge if you consider these base prohibitions with kind of sentencing predicates?
So let me make 3 points. The first would be, this is different than McGee in the sense that we have different actus reus. So the assault causing injury, the actus reus, focuses on the extent of the injury to the victim. Whereas if we take a look at assault with a dangerous weapon, you focus on the acts of the defendant. And so those are different. Whereas in McGee, as I understand it, you're looking at conspiracy to manufacture or traffic drugs versus the actual traffic of drugs. And so you're not really getting out of a different actus reus.
I thought the issue in McGee was they increased the quantity.
Right.
Is that a different element in terms of the
So
quantity?
that goes to my second point, which would be, and presumably why this court took up this case on further review, I don't believe that the case law from this court has caught up to the changes after Apprendi. And so Justice Oxley, your question, what is the base offense here, I think gets to the heart of that and where the case law needs to catch up here, right? Prior to Apprendi, we called an element whatever was, however the code editor drafted it. And so some states would say there's a base offense level and everything else is just a sentence enhancement that the judge can determine. What Apprendi says is no, anything except for prior criminal history that affects the potential for a mandatory, or for the maximum potential penalty, and then later its progeny says any mandatory minimum, that's an element of the offense that has to be charged and submitted to the jury beyond a reasonable doubt. So post Apprendi, an element, we have clarity as to what that is. So all of the decisions from this court with respect to 2.4 subsection 8 that are talking about elements versus means are really, there's a lack of clarity.
So is Williams bad law now?
I would submit Williams is bad law. I would submit that Abramson needs to be reevaluated as well. If we're going to go on the elements versus means distinction, if the court wants to hold to that, it either needs to do one of two things. One is to conform the definition of elements versus means to the Apprendi analysis, or perhaps clarify that with respect to 2.33 or 2.4, when we're talking about elements versus means, we're talking about actus reus versus mens rea. And so, Justice McDonald, I think you asked either my colleague or myself, is sharp the analysis should be applied, and we submit that it should be. That Sharp is the right decision, that Williams is incorrect, that Abramson is incorrect because of this whole muddle of what is an element and what is a means. So Justice Oxley, to get back to your question, what's the base offense? I think the Court of Appeals pointed out the folly of the state's position in footnote 8, where it talked about the peculiar nature of the Iowa assault statute. Right? There's a lot of things that are in that assault statute just because that's what the code editor decided to call assault, but other states will call it battery. The model penal code would call it a reckless endangerment of the safety of another. And so we have a scenario under the state's proposed framework here that the outcome of a case and whether or not you can amend it is entirely at the whim of the code editor's drafting. So Justice McDonald, I think you asked at the outset, what's the limiting principle under the state, if that's the case? I don't know that there is. So if the legislature were to come and say that we're going to have Chapter 901, crimes against the state of Iowa, and everything else is just a subsection, under the state's theory, then you could amend any time.
I'm intrigued by this suggestion, Mr. Dickey, that, kind of Apprendi should require reshaping the law, because Apprendi serves a different purpose. It protects your right to a jury trial on everything on all the relevant facts that have to be established. But here what we're talking about it is fundamentally a prejudice analysis. I mean, the point is you don't want people to know at the last minute what they're being charged with. And you don't have the problem you have in the federal system where there's grand jury right. So it's really just a notice issue, it seems to me primarily. And you have the separate protection that if it's prejudicial, they can't do it. So it seems to me that this wholly new and different language really is just kind of an extra protection against prejudice. And viewed from that context, what's wrong with the kind of the Williams rule that as long as it's the same basic criminal conduct, and we're talking about, you know, a different way to commit the same basic criminal conduct, which is kind of what we're talking about here. It's still running down somebody with a vehicle. What's wrong with that?
So, nothing. I agree with a lot of what you say, and I believe Ms. Allen's entitled to relief even under your view, all right? And let me explain why. You're correct. Apprendi is a Sixth Amendment issue, so it serves a different purpose. I was pointing that out only to show that if we're going to continue to bring in the language of what is an element versus what is an alternative means, we've got to explain what that means, because that means something entirely different under Apprendi, and all that, if we keep pulling that forward, all we do is confuse both the prosecutors as well as the defense. So if we're going to get away from that, perhaps we look at the actus reus, mens rea, and does that change up? So that's where under Williams, arguably, even though I believe it's wrongfully decided, but under Williams you can say, well, really the actus reus and the mens rea is just the same. Conspiracy is really the same, and so the person had notice and it really doesn't change much, okay? That's really more a change of form or substance or omission as opposed to a substantive change. So if we're going to go down that road, perhaps the rule of clarity for interpreting 2.48 would be first a recognition from a court that's evaluating an amendment that they are to be narrowly construed and that they're for a limited purpose for correcting errors and omissions, not to be used as leverage for a prosecutor. So they fail under that first, and that's a textual analysis. So they fail under the first step of the textual analysis. And then to get to what you were raising, if we're going to get away from the elements Apprendi means discussion, the next step should be, does it change the actus reus or mens rea to something else in a way that makes it unfair for the defendant? So in that step, I would suggest it does here. So they came to trial with the belief that they have to prove the extent of the injury, which they can't based on the minutes of testimony. So by changing it to a dangerous weapon, you know, they had detrimental reliance all the way up to at least 6 days earlier, but we submit to the day of trial. So it fails under that standard as well, and perhaps Williams does not. The third would be, does it increase the penalty? And if it increases the penalty, under Apprendi it's an element, but even if we're staying away from that, it unfairly prejudices the defendant. And then the last would be the second clause of the rule, which is, does it prejudice a substantial right? And it can do that in a number of ways. And it has here. I don't think they really argue that. Their only argument is that it could have been worse, right? They could have increased it to a felony, and that would have been really bad. But certainly an increase from a serious misdemeanor to an aggravated misdemeanor is a substantial right that's affected. So if the court's seeking clarity without going down the road of trying to mix with to match it up with Apprendi, that's the framework I would propose. And under that framework, we would win. I also think the framework under Sharp follows that very closely. I mean, essentially that is the Sharp framework, except you know, it doesn't have that first step where you look to the purpose of the amendment and whether or not it's a bona fide error or omission or whether there's something else going on. So for those reasons, we would ask for the Court of Appeals decision to be affirmed. Certainly remind the court, I'm sure it's well aware that there are alternative grounds. This winning on this issue, we believe, results in a dismissal of the case. The other ones result in a remand for a new trial. Thank you.
Thank you, Mr. Dickey. Mr. Mullins.
May it please the court. I just have a few thoughts While I can't concede that this rule has an overriding purpose of restricting amendments, I've seen too many of them to believe that that's the way it operates in practice or was intended. I will note that there's a plausible argument that it was assault while displaying a dangerous weapon, which was what the prosecution really wanted from the beginning, because that's what the complaint was. It just so happens that the trial information alleged assault causing bodily injury later. And so it's understandable perhaps then that the prosecution said, well, I'm going to put it back to the original charge. I have it down at this trial as in the trial information so that you can plead to the lesser offense. I disagree that the state would have been unable to show bodily injury. There are videos of the man bleeding. He's been run over. There are his statements to the 911 operator about what had happened to him. And there's Allen's concessions to the officer that interviewed him that she was the one driving the car. So I don't think, given the state of that, it necessarily would have meant that the defense could have just sat on its haunches and prevailed under the bodily injury alternative. As far as prejudice goes, the standard, I understand from McGee that it's actually, prejudice occurs if it creates such surprise that the defendant would have to change trial strategy to meet the charge in the amended information. So if that's the test, I think the focus, perhaps commonsensically, relates to the prosecution or to the trial. How is it that is going to impact what the defendant does at this trial? Because we always know that the punishment that the individual faces can vary, of course, but whether you are facing a serious misdemeanor or a aggravated misdemeanor, so long as it's apparent that the prosecution isn't going to change either way, it won't affect your trial strategy.
Didn't I write a case, it was a while ago, that said if it affects your pleading strategy, that can be prejudice under 2.48, Brethren or something like that it was?
Sure. Yeah, I mean, I wouldn't pretend that it won't have any factoring into the individual's decision whether to go to trial or plead guilty. What I'm saying is that for purposes of amending a trial information, which is the charging document and what's going to happen at trial, is the penalty going to change how you present your defense if you'd present one at all? And it wouldn't.
So if I understand the state's position, even if there's an upcharge and the penalty, let's say, goes from a D to a B, but if the trial strategy is the same, there's no prejudice, correct?
I'm inclined to say yes.
So go back to our burglary example. If you go from a third to a first, and the defense has always been mistaken identity, then on the day of trial, the defendant could go from looking at a 5-year sentence on a D to a 25-year on a B. And in the state's view, that doesn't make a difference because the strategy is always mistaken identity.
Yes, and part of why I say so is because I'm not the first to say so. In instances where the defense is denial, it doesn't very much change whether you're looking at a C or a B in, for example, the drug crimes. So, I mean,
In terms of administration, what would be wrong with just saying dismiss the trial information and start anew? Well, what is the, I guess, the practical real-world impact of that rule?
Of course. So if you say dismiss the trial information because these two are wholly new and different offenses, what it means is then the state would be free to file a new trial information. And Abrahamson thought that that wasn't a good idea because it would allow for serial prosecutions. And while I didn't believe at the time that that concern was as present as the court suggested, there is that belief that it just affords too much of an opportunity for mischief. And, you know, so long as it's within the limitations period.
Explain that to me. How so? So let's keep with our burglary example. If the state decides they want to charge the defendant with a B felony burglary, they dismiss the trial information, then they pursue the B felony burglary under a new trial information. Well, I don't see the harm in that. If they take that to trial, then they can't pursue a C under the same facts or a D. I guess I'm not understanding what the mischief is.
So as Abrahamson thought that what would occur is a prosecutor might decide not to file on either not file on every alternative that's available and hold one back, or if, as you suggest, all of these are separate and distinct offenses, then the concern would be that with each effort, you start looking at this trial, you keep that person on the line, and then you go, sorry, I'm going to file a new one. And so you keep going on and on and on. And so the court was concerned that some prosecutors might do that. And besides, the trouble then is that we still have that internal inconsistency of saying, well, they are different. So then the other way around is if you were to say, yeah, we need to put a stop to that and that it violates speedy trial, you would have to say first, well, they are you'll have to say that it's okay to dismiss, but it's not okay to refile. And with that, I need to conclude. Thank you, and we respectfully ask
Thank
this
you.
court affirm the conviction.
Thank you. The case of State versus Allen is hereby submitted, and court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.